But you know, you mentioned something that does, now that I've been a judge for a while, has troubled me. When I was on the water board, I just thought you could do anything you want, as we did in the Consumers River decision. When the record comes to the court, we're stuck with whatever the guys below did. And in the Della cases, in that decision of mine, the Della cases, there were things missing, and we can't provide them. So courts don't have the same role as the board. The board can go out and get evidence and can find bases for acting, but the court can't. We get this record, and if somebody leaves something out or somebody does something wrong, it's too bad. And so the courts have a much more passive role, and we're stuck with the record. And this happens all the time. People come to us, they don't have transcripts, and they want to know, they want to tell us what happened. And we say, well, you know, if there's no transcript, you lose. And so the burden is on the administrative agency to do it right. So that's why it's so, I keep saying it's so important that this stuff all these factors, all this analysis, all this evaluation and balancing be in the record before it ever gets to the court.
And that balancing that takes place, the balance involving each of these three beacons or pole stars, is, in your view, Judge Roby, is that primarily something that lawyers engage in? Is it something that engineers engage in? Is there some broader policy implication that means, or policy involvement that means that it's not the purview of just lawyers and engineers, it's all of the above?
Yeah, of course it is. You know, when I spent my time as water director with all these engineers, and I think we understand each other, and I think we understand that I don't have all the answers. I certainly didn't, and neither did they. And when I was at the water board in the early days of the water board, when it was just a few years old and it was fresh out of being the water rights board, we sort of had a hard time convincing the engineers they should consider anything other than just the engineering aspects of an application. And the water, you either counted it and it was either there or it wasn't. It's not a question of whether it flew past the dam and all that. But I think that engineers and lawyers all have to learn from each other, and there's, you know, nobody has a corner on what's good.
Speaking of nobody having a corner on things, I wanted to ask you a question about something that you really just brushed perhaps very lightly on in your paper. And I'm thinking in terms of your title, what is, what ought to be. Could you spend just a few moments explaining how you now believe, after this remarkable career that you have had, how you now believe that federal water law and policy interact, or should interact, or perhaps should not interact, with California's water law and policy?
Well, I think that, you know, first of all, with regard to water law, you know, Section 8 of the Reclamation Act said that the federal government has to comply in its operations of its projects with state water law. And until California versus the U.S. in 1978, that was not the law. And unfortunately, the Supreme Court decided that one right. But I can just tell you that the two water projects were operating out of sync with each other. During the drought of 1977, the Bureau of Reclamation was releasing a limited amount of water into the Delta, and the State Water Project was releasing more, yet we were bound by the same law. The difference is that the Bureau didn't feel compelled to follow the law. So, and I have to tell you this as truthfully, that during my tenure as Director of Water Sources, I had a very difficult relationship with the Bureau of Reclamation's regional director, because they treated the state like underlings. And the fact that we now have, over a period of years, acceptance of the fact that state water law does drive the show. Now, on the other hand, the Endangered Species Act and other federal statutes, Clean Water Act, all have an impact on what happens in California. And so it's not just water rights law now, there are all sorts of other laws, just like we have the Public Trust. But I do think that I'm really troubled, personally, by efforts in Congress to override state water law. And, funny, it turns like people I know in the water fields and other states to go livid on this, because they're going to be the next state to have their water rights wiped out. And all the time that I've been involved in water, we've been fighting to protect the state water right laws. So I think things are doing much better with the federal government, although they still, if you recall on the Delta decisions, that a decision of mine, the federal government appeared before the Water Board, but did not appear in the court case.
In some respects, I guess things have moved quite a ways. Aren't we at the point now where the two aqueducts for the first time are now interconnected? Isn't that, aren't you doing a dedication or something here, Rita?
I'm not doing it, but it's happening.
Well, back in the old days, we did, when the California aqueduct is a shared aqueduct,
Yes.
because you're on the and the department.
Yes.
But that was a practical necessity and made a lot of sense. And but I mean, there is a lot of cooperation that didn't always exist, and it made it very difficult when it didn't exist.
You made reference a couple of times to Porter Cologne, and I wanted to ask you to please touch for just a moment on one aspect of what I have always thought of as kind of the intersection of traditional water rights law and water quality law. And it was, the Porter Cologne Act was just the milestone in that regard, and I referred to you as kind of the author of it.
Well, I wasn't really, because Jerry Gilbert's out here, and he would correct you if you said that, because
Jerry Gilbert, correct, Rob?
we had a series of groups, task groups.
Yes.
Jerry was head, and Harvey Banks did one. And what we did, the concept of that was to get all the interest in the room. I remember we once put a comma in for the Imperial Irrigation District because they wanted a comma someplace. But the point is that we got all the interest in the room, and we moved toward the middle and a compromise from where the law was before to where we really wanted it. And as a result of that, everybody bought into the result, and therefore it passed. And I guess that's the problem with the Governor's Commission, because it didn't get everybody in the room, and so people just took pot shots at it.
Yeah, I wonder sometimes if the results of what the Governor's Commission papers led to and the legislative recommendations, if things might have been different if it wasn't right after the 76-77 drought. Because as you indicated, people were not ready to proceed in the direction of legislative or policy change. They wanted to pursue projects.
Well, I think everybody thought they had some leverage or something
Yes.
for getting things. But people always hope there's leverage. I mean, the short-sighted Valley farmers thought that something better would come in 1980, and of course it hasn't come. But
Back to Porter Cologne, though, for just a moment, Judge Roby. Okay, what you refer to in your paper is how the Assembly Water Committee, I give you credit, because as I recall, you were the head of its staff.
you gotta admit, I was the head of the staff because we only had one person.
Oh, excuse me. He was also the number 2 person on that staff. That out of that committee, out of its...
So we have to ask Senator Volk if she can actually imagine a time when the legislative committee had one staff person.
But the idea, as you said in your paper, it was merging the administration of water rights with the oversight of water quality.
Right.
Now, that was over 40 years ago. And since that happened, you have been able to observe that merger from the perspective of being a member of the Water Board, being the director of the department, and as a trial and appellate judge. Do you think it worked out as planned, as you thought it might?
Oh, I think from a legal standpoint, it certainly did. And I might add, the reason there was a staff report to the committee as the starting point for that recommendation was my boss didn't think people would like it, and he thought if I wrote the report and people didn't like it, he could just say I didn't really, I don't agree with it either. But anyway, it actually went up, it worked. But I think that there were some bumps in the road, and in the Racanelli decision, the issue of gluing together 2 different functions and how they could properly work got a little changed. But I think I think in the water board cases, which is in 2006, I think we made it clear, the court made it clear that the two operate, they can function together, and it doesn't, whatever people were worried about under the Racanelli decision was not fatal to it. And I think it's an ideal situation, particularly because the Delta is where you have this confluence of water rights and water quality. And some other states sometimes don't think they need these kind of considerations because they don't have a Delta with a state and federal project running together with all these upstream projects as well. So I think it's worked, the mechanism has worked well.
As we are here on the eve of another Bay Delta proceeding, I'm looking at Board Member Spivey Weber, and I'm hoping it'll work well this time.
Well, all I can tell you, it'll probably take 12 years to get to me, and I'll be retired by then. But, yeah. You know, that's the other problem that lawyers have, you know, is they take so long. D 1379, which was the first Delta decision of the Water Board, was superseded by D 1485 before the litigation ever got to the Court of Appeal. So, although there were lawyers filing 25 lawsuits, and it never ever got past the trial court. People just file lawsuits because that's fun to do. And I think lawyers should be, I'm serious, I think lawyers should be serious about the law and not just file lawsuits and sit around and wait. I mean, litigation is much too slow.
Carl Baranki, who was the lead lawyer for the state, I guess, in the Attorney General's office on a number of things in the resources area, and then was general counsel and eventually general manager of the Metropolitan, once told a story about how something like 20 years after he got into the Attorney General's office, at about that time Arizona versus California was decided. He was at Metropolitan now, 20 years later. The first case he appeared in court, it was Arizona versus California. And he closed the story by saying, I have a son who's 19 years old and a sophomore at UCLA, and I say, my son go to law school, and someday this case can be yours.
Yeah, I think it's essentially independent, but that's true. And I do think that we joke about water litigation, but I don't think it's to anyone's credit that it takes so long.
I wanted to ask you one more question, and then allow members of this wonderful audience to ask questions if they care to. And this gets back to sort of the what ought to be portion of your speech. You said in several ways, in ways that I very much appreciated, how Anne always had the broader picture in mind when she worked with her clients. She certainly understood and represented her clients to the absolute acme. But she also understood the big picture and how things ought to be. And the thought behind my question, really, I have to give David Guy credit for. And he referred me back to 1926, Supreme Court decided the Herminghouse decision.
Right.
It created what I consider to be a really critical moment in California water law. And it was addressed directly in 1928, just 2 years later, by the enactment of Article 10, Section 2. Justice Racanelli says the enactment of the measure which made reasonable use, as he called it, the cardinal principle of California water law. If we step back for a moment today, and we think in terms of today being another critical moment in California water law and water policy, what should we do? You gave a kind of a prescription through your speech, but do we have an opportunity now for our water leaders, our legislators, the administrators of our water institutions, do we have an opportunity to do something that's on a par with the enactment of Article 10, Section 2 back in 1928?
Well, you know, the constitutional amendment came about because riparian rights were running wild, and nobody's reined them in other than the constitutional provision, in the sense that we still don't have certainty of water rights. One of the commission's recommendations was certainty of water rights, figuring out what people are diverting, and there's a certain advantage, I guess, to keeping your cards close to your chest, and you can pretend you got something you don't have. But I think right now we don't need any major constitutional kind of approach. I think we have all of the policy things in place. The public interest has always been there, and it can be interpreted in the light of current feelings and beliefs. We have the Constitution, which gives us a firm framework for deciding what's good and bad, and we have the public trust that overrides it and makes sure that environmental values can be and will be protected. But I think we need to put them all together into a coherent policy, and then we still need to do some of the things the Governor's Commission recommended. We don't have, the legislature a couple of years ago enacted some groundwater legislation, but they weaseled and said, well, you can't go on anybody's property to find out what they're doing, and we really still don't know how much people are pumping, so when you try to adjudicate a basin, you're in the dark. I think some of the essential foundational things from the Governor's Commission report would make implementing all this policy a lot easier. The certainty of water rights, some kind of groundwater management, all of those things would contribute to making the use of existing tools work better. At least I think so.
And get us to what ought to be.
Now, we get us well, we'll never get where we ought to be, but we try.
Very good. Well, we could go on like this for quite some time, but I know that there are a lot of really interested and informed people out here. Do you have questions for Judge Roby? We have about 15 minutes. Yes, Vicki?
I have a question. This is on waste and unreasonable use.
Yeah.
In your opinion, do you think that the board could find that a use was unreasonable because of the water quality effects, even if it was not unreasonable from a water supply perspective? For example, flood irrigation. Flood irrigation can be very efficient from a water supply perspective, as efficient as other methods of irrigation.
Right.
But it causes pollution. It causes thermal pollution, picks up nitrogen and pesticides as the water is flowing over the plant material. Do you think that the board could successfully argue before the court that such uses should be compelled because of their water quality effects being unreasonable?
Well, I mean, it seems to me that, number one, you can't just argue it. You have to have facts to support what you're saying. Water quality is an essential element of what the constitutional provision provides. I think it's an unreasonable method of use if it causes water quality problems, an unreasonable method of use, an unreasonable method of diversion. So I think the two can be integrated. You just have to have you have to have some scientific or information that says this is true. And then the board could fashion maybe not a prohibition, but terms and conditions to make certain things work better. I do know that flood irrigation is still in Modoc County the way to do it, and it's not unreasonable under the facts, but it would certainly be unreasonable somewhere else. So all of these things change with the physical facts of the situation, and I think the water board has the authority to do that. Under the provision that was worked out, if the department makes a study, they can ask the department for some help. But it has the power, whether it does it or not. I think it can.
Other questions? Tony?
Well, both of you have stated that environmental values are now getting greater recognition.
By the public.
Right. And that does lead to my question, Your Honor. As I read some of the recent cases, I'm not sure they're getting the same recognition from the courts, and it is because the public trust doctrine is not considered a constitutional dimension, and so therefore we defer to the agencies.
Well, I don't think even if it were a constitutional dimension that the courts would not defer to the agencies. I really don't. I think the problem, Mr. Osman, rests with the agencies being too timid in getting before the courts a balancing act that gives appropriate weight to the public trust. And it's one of the things that I suggested, that they develop their own record and information on that. I think that I was talking to Mr. Maddow earlier about, for example, the board considered in the proceedings leading up to the water board cases the need for contributions from upstream diverters, including East Bay Mud and others diverting from the delta to contribute to delta outflow. The board accepted a stipulation between the Federal Energy Regulatory Commission and East Bay Mud as the minimum flows necessary for their streams. The board didn't do any independent, they just said, fine, we'll just accept that. It seems to me that that was satisfactory because it wasn't wrong, but it could have been a lot better. And in terms of the San Joaquin River Irrigation District, they only provided flows to the delta because the Bureau paid them. And the board said, that's fine with us. So what's the court supposed to say? You know, and I think that's the problem. We can't just invent results that are not justified by the record.
Well, but under some of the earlier reasonable beneficial use cases, the court has really acted as the trier of fact and finder of fact.
Well, the trial courts can, but in this case, what we're talking about is stuff that comes from the board.
Quickly.
We've been talking about the public trust doctrine and sort of casual mention to public trust balancing.
Right.
And my recollection from Ottawa is actually the court never actually uses the word balancing.
No, it doesn't.
In the decision, it talks about protecting trust values where feasible. It does indicate when out of historic necessity, there's a long-term reliance on off-stream uses, that in those cases, trust values might give way to off-stream uses. So I guess my question on public trust balancing is, are all the weights the same on the scale in light of Audubon?
No, I guess
Are
maybe.
there some presumptions that are read into that balancing test based on Audubon in your view?
Yeah, I think the feasibility, I think the feasibility and balancing are somewhat the same, the idea of feasibility. I don't think they're all even. I don't. And I don't think balancing necessarily implies that everything is even. I would agree, Cliff, with that. But I mean, and there sometimes are conflicts between public trust values, as you know, where the two values don't result in the same result. I mean, they don't come to the same conclusion if you protected